Moving on to Form 203, the non-exclusive buyer agency agreement. Some of you are already very familiar with this form. Others of you probably didn't even know it existed in the Forms library. But I think it's going to be a form that for some firms is going to be a pretty good fit for a specific scenario. And that specific scenario will be the fact that before you can take a buyer into a property, which means actually entering into the property, okay, under the new rules, under the new MLS rules, then you have to have a written agreement with the buyer that says exactly what you're going to be paid and that commissions are negotiable. So those two things have to be in that written agreement with the buyer before you can tour or enter the property. Now, you can virtually show property, under oral buyer agency and the license law. That is not going to change, at least for right now. But as far as actually entering the property, you got to have some kind of written agreement with the buyer. Now, as any of you who work with buyers know, some of them are simply hesitant to sign an exclusive agency agreement, but maybe it's something where you really want to make sure that you want to be able to show a particular property to a buyer and you need a written agreement. This is something that will give you the ability to do that. There will be any number of other kinds of agreements. There have been people who have released other documents to sort of fill this little gap. I think a common title for it seems to be touring agreement. Right now, we don't have a touring agreement in the forms library. There's not one that I'm aware of, at least as of the date of this video. There's not one that's widely available that's compliant with North Carolina law, but there probably will be one pretty soon. Probably agents and firms will do it. It'll probably be sort of like some of the custom addendums that we've seen to Form 2T for escalation clauses and things like that. You will see some of these things in the interim, and then as that input is received, by the forms committee, then they'll have to evaluate whether it's something that is appropriate for the state association to tackle as well. Right now, as far as going into this new landscape of MLS rules, this agreement will give you it'll check those boxes to be able to have a written agreement in place to be able to show a buyer property. And beyond that, it's also going to give you a limited amount of agency to make sure that you can make an offer if things go well at the tour. Some of these, touring agreements, as far as the ones that I've seen early on in this process, they don't give you that authority at all. Mind you, your agency is determined by written agreement. Your scope of your authority is determined by written agreement. Unless you're under oral buyer agency, in which case you should still have some kind of written a document that says this is what our oral agreement says. Now, I know that sounds a little funny, but in the Model Office Policy Manual, there is exactly that. It's just a letter you send off to the buyer once you've gone through, you've come to terms for oral buyer agency, at least under the current rules, and then you would send that letter just saying, hey, just so we're on the same page, okay? This is what we talked about in as far as oral buyer agency. If it's not your firm's policy to currently do that, that's something you definitely may want to consider. In any event, you may also want to consider as a firm that, instead of doing a touring agreement where you may or may not be paid at all or may not have any authority at all to do any kind of agency, then doing a non-exclusive buyer agency agreement so that you can have that agency. This agreement is exactly what it sounds like. It's an agency agreement with the buyer, but it's not exclusive, so the buyer could technically go to another firm. It does come with that risk, certainly. But it is compliant also with the license law and with the settlement. So it is a document that is already existing that definitely will do those things, okay? And what we have here on the screen you'll see that these edits are very similar to what we're in 201, okay? The exclusive buyer agency agreement. So we have changes here to, first the fee is defined right here in 3A, okay? Modification of fee, We have that's not been changed at all. Additional compensation, buyer has to specifically consent to it. And then we have a note here that was already, as you can see, most of it is not highlighted at all. It was already there. Some technical edits to make sure that it complies with the settlement agreement. Okay. And that's pretty much it on this form. It's going to continue to be a simple form. It is 5 pages. That's it. And then you can have all the authority you need to be able to show a buyer the home, and if everything goes well, be able to submit an offer. And when you submit an offer, then do the exclusive buyer agency as part of that. And if you want, if the buyer's comfortable with it, you could limit the exclusive agency agreement to just that property. You can limit the scope of the property right here in paragraph 1. Same thing in the exclusive buyer agency agreement. You don't have to make it for the entire state. Some people do, because they don't want the buyer to, just move markets a little bit over or a little bit out of the jurisdiction, so that, they can try to avoid paying the agent a fee that they otherwise have earned. So there's that. But at the same time, there's check boxes right here: locating suitable real estate or following, specific property. Those are each totally valid and have been for a long time. This form has been around for quite a while. Last time it was revised was in 2022. So, it is a form that, could very well be a solution, or, something that may work for some of your agents and maybe not for others, depending on how, they run the practice and buyer agency. So, in any event, those are the changes to Form 203, and maybe a little bit of context of how this form may fit into your practice going forward. And we will move on to newly revised Form 220.